So I'm asked what my thoughts are on the recent budget provisions which allow HMRC potentially from 2020 to once again become a preferred creditor in insolvency cases. This is effectively a return to the position as it was when the current Insolvency Act was first enacted in 1986, where HMRC then had the ability to claim certain amounts of VAT, PAY and NIC as a preferred creditor and effectively get the first bite of the cherry from a company or individual's assets. This was removed at the time of the 2002 revision of the Act, but now has been reintroduced by government, as government is currently interested in maximising revenue to assist the country with its economic recovery and to potentially shield the country from any effects of Brexit. It is estimated that the introduction of preferential status for HMRC should swell the national coffers by around £185 million per annum. However, this will not come without complications in that in a situation where HMRC have preferential status above that of what are known as floating charge holders, i.e. normally banks and lenders who hold security over a company's assets. This will, of course, mean that HMRC will be paid before those banks in terms of the proceeds of certain asset realisations, and it may lead to a revision or reconsideration of banks' lending policies to businesses when they consider that in the event of difficulties they will rank behind HMRC for repayment. In addition, ordinary trade suppliers will then find themselves effectively in third place in the pecking order behind HMRC, any secured lender, and therefore finding themselves in the third position in terms of recovery from insolvency assets. The introduction of preferential status for HMRC may also affect the behaviour of HMRC in terms of their debt enforcement practices. There is a school of thought that since the abolition of preferential status for HMRC, this has made them more aggressive in their pursuit of unpaid tax and more likely to issue formal enforcement proceedings. However, it would be equally valid to be of the view that when HMRC know they're going to have preferential status from the assets in an insolvency estate, this may also still encourage them to continue to issue a high number of bankruptcy petitions and winding up petitions in the knowledge that they will get the first bite of the cherry. So I don't believe that it's necessarily the case that the introduction of preferential status for HMRC and their promotion up the pecking list will mean that they are any less active or aggressive in pursuing businesses for unpaid tax. For example, in takeaway restaurants, I am aware that in recent times there has been an increase in visits by HMRC inspectors who will undertake, perhaps on 2 separate days in a week, a test meal at a takeaway or restaurant with the intention of then formally visiting the business perhaps a few weeks later to check whether those receipts have passed through that business's records. If they're found to have not been passed through the records, then HMRC are very likely to raise significant estimated assessments against a business and can backdate these several years, giving rise to liabilities which appear to be even many multiples of the business's annual turnover. These assessments can be combated with specialist help. The approach of HMRC is that it is for the business owner to prove that there isn't widespread abuse of accounting for income, and these scenarios can be extremely difficult to defend for a business proprietor.